or an informal request for information or a deposition question, however it comes about, is who is asserting this right of privacy? Generally speaking, the right of privacy will only protect individuals, not corporations. The case law on that is in the materials. A corporation can assert the right of privacy on behalf of certain individual members sometimes. So the first thing to think about is, can this entity even assert this right of privacy? If they can, like we talked about, the right of privacy is not absolute. It only protects the reasonable expectation of privacy against a serious invasion. So what comes next? What comes next is a balancing test. We have to figure out, under the particular circumstances in front of us, whether the right of privacy should even exist. Now, one thing that has to happen, always, is notice has to be given to these third parties whose rights of privacy may be invaded. And sometimes there are very simple ways to do that, statutory ways, such as when you're sending a subpoena and you have to send a notice to the consumer, and sometimes it's not quite so obvious how to do it. So Chris, do you want to talk about that a little bit?
Yeah, I mean, I think that the biggest roadblock that I see is this notice to consumer requirement. And I'm always, anytime I'm looking for records that involve a third party, I always go back to CCP 1985.3 and look and see, is this consumer or witness here that I'm trying to get records about on that list? And I mean, there's just so many type of things, but we got veterinarians on there. Don't have a lot of call for those kind of records, but still, if you want that veterinarian record, you got to comply with the notice to consumer requirement. Also, schools. So if it's a custody case, you're going to get school records. You got to deal with 1985.3. I'm dealing it mostly with regard to bank records. And what happens is that I'm sending a subpoena. I know that the other party banks at Wells Fargo, so I send a subpoena to Wells Fargo saying, give me all statements for all accounts in this party's name, whether held jointly or individually, with, and then I get back, well, hey, yeah, I can't give you statements for one of these accounts because they're held with a third party. There's no notice to consumer. Well, I don't know who the third party is. I don't know if it's their sister, mother, brother, whatever. I don't know who the person is. So I can't serve the notice to consumer. So I can't get the records. So now I have to go jump through additional hoops of special interrogatory or taking the deposition to find out who is that account held with so I can serve the notice to consumer. This is just a huge roadblock. We also see it when we're dealing with a professional practice that needs to be valued, or we want to know about the person's income and they're involved in a professional practice. So I want records, whether that's a medical practice, an accounting firm, a law firm. Well, these are all client records. How can I get records relating to that professional practice without giving notice under 1985.3 to all the clients? I'm not going to get their client list. So that leads into automatically limiting our ability to get information. It's going to have to be redacted to basically sanitize the records of all information about these consumers, the clients, the patients, whatever, because otherwise we have no ability to get the records. So 1985.3 is the biggest, I think, roadblock for us to overcome.
Keep in mind that 1985.3 deals with the type of notice that's required when you're sending out specific subpoenas. But there are other ways to request information, informal request, for example, that don't come under that statute. And when you're doing that, you still have to give notice to those third parties. And sometimes you can do it directly. There's statutory authority for the party who is providing the discovery to give notice to the third parties. And for example, if a husband might have to say to these third parties, hey, wife is seeking this information. If I provide it, it will disclose these certain things about you. Do I have your permission to do it? And the Colonial Life case talks about a judge making orders under certain circumstances when that's really the only way to effectively give notice to these third parties. But they have to get notice somehow. We talked earlier about figuring out, first of all, can this entity even claim a right of privacy? Now we have to figure out, is the type of information that they're claiming the right of privacy with respect to even private? And there's no bright line rule other than the 1985 list, but there are various things that the courts have already said these are clearly zones of privacy. Those include membership in associations, anything dealing with personal finances, which includes the will and estate planning documents of a living person, medical records, employment history, personnel records, and arrest records. So we have cases with regard to each of those that say these fall within the constitutional rights of privacy. It's obviously a non-exclusive list. So let's say there's a determination that somebody wants to assert a right of privacy. How do you go about doing it? And the answer is there's various ways. It's not like a privilege where it has to be done in a very specific way within a very specific time frame. We know that the third party themselves can claim the right of privacy simply by serving an objection, or of course by filing a protective order. We know that the party to the litigation can assert the privacy right on behalf of the third party.
Well, let me ask you on that one. I mean, so if I'm taking a deposition of the other party and I'm asking questions that relate to a third party, you're saying that that other party, the counsel for the other party, can raise an objection on behalf of a third party.
I am.
And they don't even represent that third party.
I am. I think they can and they should, and I think the Weingarten case, which is in the materials, talks about that specifically. Constitutional rights of third parties are easy to assert, although not necessarily easy to sustain. As we talked about, as I mentioned before, unlike privileges, they're not easy to waive. There's law that says even a failure to timely object to a discovery request may not waive a constitutional right of privacy as opposed to various privileges. Right of privacy is so important that it's one of the few occasions where it's proper to instruct not to answer at a deposition if somebody asks a question that may invade the constitutional right of privacy. That's a very short list, despite what we see in common practice. So if you're objecting, one of the things you can do is ask for an in-camera review of the materials, and you have a right to that. And the Schnabel 1 case talks about that. So before anything is produced, if there's been some motion practice, one of the things you can do is ask the court to review it in camera. If you're doing that, it's recommended that you provide a detailed declaration to assist the court in its review. Tell the court what it's seeing. Tell the court why you think it's privileged. Tell the court, not privileged, protected by the right of privacy. Tell the court any ways that you think the material could be revealed, for example, subject to certain protective orders. Guide the court along that analysis. In the Babcock case, all these cases are on the CD that came with your materials. The Babcock case provides a very nice roadmap of exactly what that declaration should look like to be helpful for the court in its in-camera review. So you've sought some material, and somebody has objected on the right of privacy, and now you have to figure out, should this material be produced? There is a case directly on point that we use in family law cases to do this analysis, and it's Schnabel 1, California Supreme Court, 5 Cal App 4th, 704. In the Schnabel case, the Supreme Court gave us the exact factors that the courts should be looking at in conducting this balancing test. First of all, we look at the need for the party who wants the information. How would the requested information help resolve the issues at hand? What is the relationship, if any, between the other spouse and the third party? Has the information requested already been provided or made available? What are the specific reasons to distrust, if any, to distrust the information that's already been provided? That's one side of this balancing test. The other side of the balancing test deals with the privacy factors, the nature of the information sought, the inherent intrusiveness of the information being sought, and any specific showing of a need for privacy, including any specific harm that the disclosure might cause. So the point here is not just that the California Supreme Court has given us the analysis for our motions and the declarations in support of the motions. The point here is that it's truly a balancing test. And if you walk away when somebody reflectively says constitutional right of privacy, even if you agree that this information is private, you're missing the point. So,
Okay, yeah, I mean, I think that so we know we're in for a fight. We know we're not going to get the records easily. We know that there's going to be this right of privacy objection. And we know we're going to go through this balancing. And it's going to wind up with a protective order, limiting our right to use the information to the case, limiting what we can share, with experts to our client.
there is a presumptive right to a protective order. If a court conducts this balancing test and decides that it does want the material produced, you have a presumptive right to a protective order to keep this material private.
And that limits it to the case. And, and if there's been examples of information being leaked outside of the case by a party, that could be significant and may destroy that party's right to get information. But we know we're going to do a protective order, and we also know we're going to do redaction. And we're going to have to take out information that is unnecessary to our purpose. And where I'm seeing this coming up is valuation of businesses, valuation particularly of professional practices, where we want all the financial records, and I want those electronically. I don't want a printout. I want the QuickBooks file, or however they're maintaining it electronically, to give to my expert. Now the problem is that if you're dealing with a medical practice and you ask for their QuickBooks file, well, now you're seeing all the patient names, all the patients who paid. That's protected under HIPAA. The business cannot give that information. So now we're looking at how do we overcome that. The same thing for a law firm. I can't give, if I were subpoenaed, I can't give my QuickBooks file because that's going to contain the names of my clients, and some of those clients aren't known. There's no public filing, so those I have a duty to maintain that confidence. The same with an accounting practice. And maybe your answer is like, okay, fine, give a 1985.3 notice to all the clients. That's not going to work. I mean, what firm is going to want to notify all of their clients? Oh, by the way, I'm going to give all your financial information or private information away in this case. That's just not going to happen. So we're going to redact. And you can't redact an electronic record very easily. So we're looking at getting it out of the QuickBooks file and dumping it into probably an Excel. So they're taking it from the accounting software that they're using and transferring that over to Excel, where now we have a big spreadsheet where we can make changes. And Patrick, what are you seeing in terms of data dumps or converting it to an Excel? What issues are involved there?
Yeah, I mean, I've had it done that way. Obviously, you're trying to put unique identifiers on each of the patients or your clients, things like that. But I've also had it where I've been able to go on site and inspect the records that I need to without, any redactions. And we were having a discussion on whether or not that still would be in violation of HIPAA, or whether or not that would be sufficient for your clients. I mean, if you're not leaving with the information, the accountant's just on site reviewing what they need, and then, taking notes and leaving with it, is that still going to be a problem?
Yeah, and that's the real issue, I think, and I see that being offered a lot as a solution. Oh yeah, just come out inside and take a peek. Well, they're still looking at the records, and I think that if we have a duty to maintain, or the business has a duty to maintain confidences of their patients or clients, that allowing any third party to look at the records is just the same as producing those records. So I don't see that as being, a great solution, but I see it happening a lot. And so, it's just something just very, very practical, that we know we need these records, but there's these inherent limitations in getting it. And the only way that I've seen on really is the data dump, and basically taking it out of their electronic system and putting it into an Excel format, something like that, that we can manipulate, change patient name to patient number 1, 2, and 3. But that also then raises some issues, is what other changes were made to that data.
Exactly. You'll never know if you ended up getting all of the information or just a subset of the information once it's redacted.
Okay.
One thing we know for sure is that however it's done, and obviously it varies case by case, but that the court's orders in this regard should preserve the right of privacy to the extent possible. And that there's case law that upholds a court order that doesn't even allow the client to review the materials, only the lawyer and the expert. So you can argue and negotiate and go to court seeking very robust protective orders to protect the confidentiality of information.
And I've seen that before, where we're saying, okay, produce it just to the lawyers, not for the client to look at. And, if I were on the receiving end of that order, I would be objecting to it, because it's a client's case. I mean, the client needs to participate in the action, and whether they're going to review all this stuff or not, I don't know. But if I've excluded it from them, I'm taking on now some liability, because, I'd rather push that off to the client and say, everything that I get is given to the client for them to review, because, hey, they're going to maybe catch things that I didn't. And if I've not given them the opportunity to do that, now I've taken on that responsibility for myself, and now I could be subject to a claim that, hey, I should have caught something, I should have gave it to them. So I'd be objecting just to protect, myself and the client, but if that was the only way to get the records, I guess that's what we'd have to do.
In some circumstances, if trade secrets are involved perhaps, or otherwise, I think it is. Before we leave Schnabel, I want to talk about the evidence that was provided to the court when it made its orders. What happened in Schnabel is you had kind of a two-man corporation, and the husband was a 30% shareholder. The shares were community property. And then his buddy was the 70% shareholder. And as we'll talk about later, it became very clear that the corporation and the guy's friend were really acting in concert with him to stick it to the wife. And there were a whole lot of Schnabel cases that came out of that. But in this case, in Schnabel 1, certain limited financial information was produced, such as a profit and loss statement. But the wife didn't believe it, and she submitted a declaration from her forensic accountant saying it's not good enough. I need the following documents so I can look behind the P&L, and I can test the P&L, and I can see whether or not it's true. And that was good enough for the California Supreme Court in Schnabel. Even though the P&L ultimately was produced, the declaration from the accountant saying this is what I need and this is why I need it were enough to carry the day and get the information, the tax returns, the bank statements, the payroll records to a certain extent, and the like. So if you're lucky enough to have a forensic accountant on a case, when you're dealing with this, a good declaration from him or from her setting forth exactly what they need and why they need it is very persuasive. Patrick, are you asked to do those from time to time?
Yes, pretty regularly. And laying out, and even when it comes, if a discovery referee even becomes involved, I've had to attend those and, discuss it, go through with the discovery referee exactly why we need the records and, for what reports each of those records is going to be applicable to.
One other point on the protective orders is that, I see these being proposed pretty regularly, and it seems like a very similar forms floating around out there that we're expected to sign. But I would be very careful about those because they really tie our hands too tightly, I think, if we want to go to court. Most of the protective orders say basically that anything that the other side produces can just be stamped by them as confidential. And once they've stamped it as confidential, then pursuant to this order, it just says it has to be filed under seal, can't be used in court without, a court order, basically. And, we just have to think about, okay, if we're actually going to put our case on in court, if we're going to go to a hearing, we need to present that information. And how can we possibly do that under the terms of this order? If everything is under seal, we're never going to get our case put on. We can't really file anything. It just becomes very impractical. And I actually got into trouble one time many years ago because of a protective order that I hadn't read very clearly, and I'm here trying to introduce evidence. It was a jury trial, but trying to introduce evidence to the jury, and some of these papers were protected under the protective order. And it's just, it becomes very, very difficult. So I'm reading those very carefully and trying to limit it to say, hey, I promise not to use this stuff and distribute it. But if I have to go to court, I'm going to use it in court. I'm not going to, I need to be able to put my case on.
That's a good point. All right. So let's talk about some examples of aligned third parties that we see a lot and the issues that come up a lot.
The big ones are the new spouse, the new mate, family members, business partners, friends, that do business with the other party or related in a custody dispute, employers, usually smaller employers who will manipulate records for the employee party, employees of that party, sometimes teachers, therapists, attorneys, accountants, trustees is a big one that I deal with. These are the kind of parties that are typically aligned with one side, or maybe aligned with one side that we know that we're going to have some problems with.
All right, well, let's talk for a minute about new spouses or new boyfriends or girlfriends. This comes up for obvious reasons. It may be income available for support. It may be custody issues. It may be fees. With new spouses particularly, we have an additional layer. It's not just the constitutional right of privacy, but there's also actual privileges built into the evidence code that we have to consider. And for some reason, these seem to be frequently overlooked. I can't tell you how many times I've asked at a deposition somebody about, what their new wife said to them, and they give me the answer. And oftentimes it's about things that the exceptions don't apply to. Evidence Code 970 and Evidence Code 971 talk about a right not to be called as a witness against your spouse. Now, there are exceptions to this when there's a dissolution matter pending, if property and debts are not adjudicated, or if support is an issue. So you can call the new wife to ask about issues related to support. But you can't call the new wife to ask about custody issues. So if something goes down in the house with the new wife, and the new wife was a precipient witness to that, and you want to call her and you want to say, how many times did he hit the kid and how drunk was he when he did it? Absolute privilege not to be called as a witness. There's no exception. And I will tell you, each and every time I deal with a bifurcation request of status, I ask that the judge condition it on there being a waiver of this right with regard to custody of both of the new spouse and of the party themselves, just like there's a waiver with regard to property issues and support issues. I have yet to have that request granted, but I'm hoping that I'm ahead of the curve, and in 10 years it'll be on the Judicial Council forums. It is such a loophole, and it really allows for some mischief, I think. Chris, have you seen this?
Yeah, I mean, I've seen it requested, and the other thing is, even if you get the other party to waive their marital privilege as a bifurcation condition for an early divorce, well, what about getting their new spouse to waive it as well? Because if you got the other party to waive their side of the privilege, fine, they can be called as a witness, testify against their new spouse, but it's typically the new spouse that we want to call as the witness, and they hold the privilege and they haven't waived it, so we haven't really accomplished anything unless we get them to sign it, and that's a real long shot.
That's right. They both have to waive, or, as I see it, no bifurcation, but we'll save that for another program. Evidence Code 980 also deals with the marital privilege. This one deals with confidential marital communications. And this one doesn't have any exceptions, whether it's for property or for support or for custody or anything like that. So keep this one in mind. It's not just a constitutional right of privacy, although that's what we see, but there are privileges that come into play as well. Chris, what about with regard to new maid income and support? To what extent can we get around a right of privacy when those issues are?
Well, we have, case law and statutes now that we have to also contend with. And for spousal support purposes, it's basically a hands-off. We cannot do discovery of a new maid or new spouse's income for purposes of spousal support. So if that's their goal, or the reason why we want that information from the new spouse or mate, we cannot get it. Child support also has the general rule that we cannot do discovery against a new spouse or mate for purposes of child support, but there is an exception if the information is necessary, really like a best interest, almost like it would be detrimental to the child not to get that information because there's some contribution for living expenses by that third party. So we have to make pretty stringent showing to even get the records in a child support case. So we have to look at those issues. And also I have a question of why do we even really need it? I mean, one, if they're filing a joint tax return, we're going to get it anyway, at least their tax info because they filed jointly. Now, if this third party, the new maid or spouse, is paying for the other party's living expenses, and this is typically why we're asking for the info. We're saying, hey, they're getting a free ride here by the new maid or new spouse. Well, why do we need the third party's records to show that? I mean, we can get that information directly from the opponent because they're going to say on page 3 of their income and expense declaration what their expenses are. And if they're being paid, all those expenses are being paid by a third party, then it's going to show 0. If they lie and say, yes, I'm paying rent and mortgage and all this other stuff, well, we can do discovery of the opponent and say, okay, well, show me records that you actually are paying these expenses. And if the opponent cannot produce those records, then we can argue to the judge, well, hey, they don't have any expenses. They have income, but they don't have any expenses. So their need for support is a lot lower than a normal person. Or their ability to pay support is a lot more than a normal person because they don't have any records of any expenses. I think the burden is on them to go to the third party to get the records to show, yes, here's what our arrangement is. They pay the expenses, but I pay the person, here, or it's a loan, or whatever nonsense it is that they have with a third party. That's on them to prove that. So why do we even need to go to the third party?
So it's one of those cases where the burden might shift because the relevant information is particularly in the possession of one party. But Patrick, isn't it better to get it straight from the source?
I prefer to get it straight from the source personally. You never know what's been manipulated, and we were talking about that earlier about if getting these records is going to be limited just to the issue of child support, could it be relevant for the issue of fees, attorneys' fees?
And this is a tough one, because if you look at the statutes, those limitations on new spouse, new maid income deal with child support and spouse support. But yeah, if you're making a motion for attorney's fees and you're saying that this other third party is paying for their living expenses or attorney's fees, well, it's not a support motion. So technically, those statutes don't apply. And so in one argument could be made, it's fair game if the issue is attorney's fees. My counter is that, at least for attorney's fees under Family Code Section 2030 is just another name for spouse support as far as I'm concerned. And the statute itself, as amended now, requires that the court look at the Family Code 4320 factors in making a 2030 award. So what's the difference? So why shouldn't the limitation on new spouse income for spouse support purposes apply also to a motion for discovery on attorney's fees? I mean, I don't see a big difference between the two. But, there's two sides to that one.
There are. It's an interesting point. We don't have time to go into it further today. We're going to hold questions if we have time at the end, then we'll take them, okay? Thanks. All right, and there are a couple of cases, again, that are in your materials that deal with this issue of to what extent, when there's a third party paying expenses, can we look into the third party's income? Or when there's a new spouse paying expenses, can we look into the new spouse's income? And again, it won't surprise you that this comes down to a balancing test. What do we actually need, and why do we need it?
Yeah, we were talking about it being limited to just on the new spouse, if you do get the information, it being limited to just the W-2s and the 1099s. And I brought up the issue about, is that necessarily going to be completely sufficient? Because if you have a situation where the new spouse is paying living expenses by virtue of depleting assets, then, W-2s and 1099s aren't going to show that.
And that's what Patrick's referring to in the family code. The child support section dealing with this basically says, you can't get the new spouse, new maid income information unless, be detrimental to the child to exclude it. So, and then it says if you do qualify under this exception, then you're only going to get W-2 and 1099s, which is like, okay, so what? That's not going to really help us. But then there's a second escape clause that says, unless it would be unjust or inappropriate to limit it to those items. So again, I think another area for an accounting declaration to show that why those tax forms would be insufficient to deal with the issue that we're concerned about.
And we're talking about Family Code 4057.5 right now. All right, business partners and shareholders and corporations.
Well, Patrick, what are you seeing in terms of relevancy or issues that you're dealing with when you're trying to get records from a third-party shareholder or partner?
Yeah, I was saying earlier on that, I'm finding that if, one of the parties has an interest in partnerships or corporations, I haven't been finding it being a problem getting, the initial source documents such as K-1s, tax returns, financial statements. But probably when you want to start to get into general ledgers, credit card statements, bank statements for those entities, I've seen where they try to object to producing that information.
And this is a problem because, these other parties, even if witnesses are aligned with the other party, understandably, they don't want to be involved in your, crappy divorce case. They don't want anything to do with it. So, and that's understandable and legitimate, and they don't want their financial information being out there. So we need to protect them. And it can be done pretty easily with some redactions. But, we have payroll tax returns and employees here. I mean, the company has a legitimate legal obligation to protect the privacy of its employers and customers. So we're going to come in with all of these objections that we talked about based on privacy. But even as between owners or partners of the company, there's issues there too. Why should we know what the other partner made or the other shareholders received? That's what they're going to say. And what we want to know is, well, was there unequal treatment? Were there changes made in the way that the business operated here all of a sudden because of this divorce? And we want to know about that. So one way we can deal with it is just to redact out the names of the other owners and deal with it shareholder 1, 2, and 3, or partner 1, 2, and 3. Take out the names, but now we can see their percentage of ownership, how much was distributed to them. All of these things should, be then evident to us whether any changes were made. Problems come up, though, is what if it's only a 2-shareholder or 2-partner company?
Like in Schnabel.
Like in Schnabel. So now, great, we've redacted out the name of other partner and we've put in name, some whatever code for them, but everybody knows who it is. So how are we protected that person's privacy because we know who the person is? Those are their kind of initial responses that we're going to hear, and we need then to be prepared to overcome those. And with I think the declaration of the accountant to come in and say, here are the things that we're seeing that were changed in the company that justify us to pry a little bit deeper. Patrick, what are you seeing in terms of changes that are made to the operation of the company that would cause sort of suspicions that one partner or shareholder is being treated differently?
Well, if there's any, post-data separation, if there's any changes, for example, to operating agreements or partnership agreement or shareholder agreements, if all of a sudden there's a decrease in the amount of distributions that are being made, if there's unequal distributions to the shareholders, generally seeing that. A lot of times, if they're refusing to produce documents related to credit cards that are held by individuals, you may even see credit cards that are not in the names of one of the spouses being utilized by one of the spouses in the business. And so it may not even be as simple as just getting a credit card from the company that's held in their name. You really have to be, cognizant of the fact that if there are aligned parties, they may be doing a lot of things to try to help out the in-spouse, if you will.
And that's what was done in Schnabel. The court pointed out that there was a large retained earnings. So this company had been generating a lot of income, but wasn't distributing it. And so that was significant to the court in Schnabel to saying, we need to look behind here and see what's going on, and we need to understand what's happening as to both owners of this company, because all of a sudden they're hoarding all this cash, and is that being done for legitimate business reasons, or is it being done to protect this other party here in the divorce? And we've seen where one court in Blazer came down on the side saying, yes, that was legitimate to hoard some cash because they wanted to go into a new line of business, and they needed to reserve some money. So there's cases that say businesses can do that, and it won't be counted as income available for support. But we need to understand the facts, and the only way we're going to do that is get behind it. If we just get our client, the K1 for the other party, this informational return here that's showing how much money was distributed to them, how much money was their distributive share, we're missing the picture here. What about the other shareholders or partners? What did they get? We need to see that information in order to get the whole picture. We also want to look at things like, did they change their accounting, their inventory system? There can be some very sophisticated changes made to the operation of that business that are going to affect profitability. Inventory. Are they buying a whole bunch of equipment that they didn't need to do before? Did they change their way that they're doing depreciation? These are very sophisticated issues that we got to dive deep into that we're not going to just see on basic source documents. The Schnabel case also has talked about the ability to add the other spouse to the stock. So in Schnabel, the shares in the company were held by husband. And the Schnabel court pointed out that 1101C allows us to add the outspouse to title to the stock. And, it's an interesting idea, but it may not be a great idea. Once now they're a shareholder of record, now they're going to get a K1, and now income is going to be flowed through to them, and they're going to have to pay taxes on it, and they could really get hosed, because we could load them up. I mean, if I were on the other side, we'd load them up with a whole bunch of phantom income, and now they got a whole bunch of taxes to pay. Or there may be legal issues that are involved with being an owner that they don't want to have to be. If they're an owner of record, they're a shareholder of record, and now when the loans come due for renewal, they're going to have to probably personally guarantee those loans, and now they're personally liable on a business debt to this third-party creditor. So I would think about whether it's a great idea, whether you really, really want to have your client as an owner of record of something.
All right, so one of the things we've tried to talk, or we're trying to talk about, are kind of escalating tactics to get this information. And the first way to get it is to try and avoid these objections entirely by just trying to get it informally. We know that these third parties don't have fiduciary obligations to the spouse, to the other spouse. But to what extent does a spouse have a fiduciary obligation to pressure third parties to give up the information without a fight? I think the answer is unclear, but Schnabel talks about it in one case. In the Schnabel case, the husband, the 30% shareholder, has statutory rights of inspection that come along with being a shareholder. Statutory rights to review the records and the like. And the court in Schnabel said it's a breach of fiduciary duty in light of his statutory right of access to hinder the wife's opportunity to get equal access. That's as far as we've gone in the fiduciary duty realm with third parties. But it seems to me we should be able to go further. All the fiduciary duty statutes that we're not going to go into here, but you all know them, that talk about the obligation, sometimes without request, to provide material facts and information, and which should in large part obviate the necessity of formal discovery between the parties themselves, in my opinion, impose an affirmative obligation on a party to do their best to get material facts and information that's held by third parties. What do you think about that?
I think I would limit it a bit. I mean, if we look at the discovery model, we know if we serve an inspection demand on a party that they have to produce those records which are within their possession, custody, or control. And so that's the discovery standard. Under a fiduciary duty, if there's a demand for disclosure, do they have to get documents that are not in their possession, but are within their control to get? And so I think if it's required under discovery, it's probably required under the fiduciary duty disclosure standard as well. But then what does control mean? And so I've looked at those cases, and they're in the material, and for purposes of discovery, control means legal control. So like David was talking about in terms of corporations, a shareholder under the Corporations Code has a right of access to corporate records. So the shareholder has legal control to get those corporate records. If we're asking for bank records, a party has legal control over their bank to demand production of their bank records. Credit card records, there's legal control there. So I think if a demand for disclosure is being made that they produce their bank records, even though they may not be in their possession, they have a legal obligation to go to the banks, credit card companies to get those. But it's more complicated. What about friends, family members? They don't have legal control. I mean, they can ask, but they don't have any legal control over those people. So that's an area we don't know about. That, I think, though, certainly hindering actively going to the family member and saying, don't produce it, that would be a breach of fiduciary duty. And if we could find evidence of that, that would be awesome. But whether they have to actually go and get it is questionable in my mind.
Do you think one spouse has a duty to the other spouse to get estate documents?
I mean, these are the things, it's like we know that we have cases where, you know, if we're on the in-spouse side, they have access to all the information. I mean, they can pick up the phone and talk to business managers, attorneys, accountants, whoever, and get whatever they want whenever they want it. And they have the juice to get that information. And they use it when it's helpful to their case. But then when the other side needs the info, you know, do we have to make those contacts available to the other side? And I think in the spirit of disclosure, we should, but I don't know if it came down to it legally if we have to or not.
Well, I don't think there's a case on it yet, but I'd be very comfortable arguing that in the spirit of disclosure, you must try. You must try. It's not enough to say I didn't hinder pursuant to your fiduciary duties. I think you have to go further and at least try.
I
If
tried
it's-
and didn't get it, sorry.
Right, well, fair enough. All right, formal discovery, subpoenas and depositions and the like of third parties. Chris, briefly.
I mean, the only thing here in terms of, you know, I mean, you all know how to issue subpoenas and all this. I think that the issue that I'm coming up with is out-of-state records. So, you know, we can't really get stuff out of state. And so if we're dealing with an out-of-state witness, we're hampered here. We may need to go to that state to get the information and not just rely on a subpoena that's issued by a California court to, you know, reach across state lines. Sometimes, you know, nobody objects to it, but I do see that objection being raised, and then that raises that whole question.
Well, I think this calls to mind the distinction between a subpoena that seeks business records only and an old-fashioned deposition subpoena that says bring your records to the deposition. If you're serving a business records subpoena, you're limited to getting business records, and not all documents held by a business are business records. The case on point deals with, can I send a subpoena to the court reporter and say, give me a copy of the transcript. I don't want to pay your $6,000 fee that you're charging me to purchase the transcript, just give me the transcript. And the appellate court said, well, the $6,000 is an unconscionable fee for a deposition transcript, but a deposition subpoena cannot be used to get the transcript because the transcript is not a business record. It's a product of the business. And they analogized it to sending a subpoena to Ford and saying, give me an automobile. You can't do that. So you have to be careful when you serve a regular documents-only custodian of records subpoena. Number one, that you're actually seeking business records. And number two, like Chris talked about, you're serving it on a custodian and saying, custodian, give me what's in your custody. And that custodian isn't going to have the documents out in Rhode Island in his or her custody. But compare this to a deposition subpoena and a document demand, where the old-fashioned possession, custody, or control standard is applicable. So if I serve a deposition subpoena and I say, bring these documents, they may be located in Rhode Island, but they're clearly under your control, now you're obligated to bring those. Now, do you need to actually take the deposition? Well, ideally, if you can afford it, but maybe you say you don't have to show up if you give me the documents. So there's a way around some of these things if we look carefully at the statute.
And there is a couple years ago, a number of states have adopted this Uniform Act on interstate discovery. You know, and in the old days, we'd have to go get a commission from California to allow us to have the subpoena, you know, issued out of state and go through, jump all these hoops. But California and a number of other states have adopted this uniform law that basically allows an attorney in one state to issue a subpoena in another state. And so it's made it a lot easier, but still, you know, I would deal with local counsel out there to understand what is their form and their procedure and how are things done, and still get them involved, but it's become a little bit easier to get this out-of-state stuff. You talk about joinder?
Yeah, let's close by talking about joinder, which is really kind of the atom bomb of dealing with aligned third parties. And again, we have the Schnabel case to deal with this, although it's not the same site, because this now had been up to the Supreme Court several times. And by the time it got up to the Supreme Court on this occasion, this is what they had determined. As Chris pointed out earlier, there were a whole lot of retained earnings in this corporation that seemed unreasonable and seemed like they were being retained only to kind of stick it to the wife with regard to support. They also found out that the corporation was paying entirely for the husband's attorney's fees. And they also found, those were the two main things that they had found. So what was the remedy? Well, the remedy was, the court said, because the corporation is actually holding what appears to be community property in these retained earnings, and because the corporation is acting in a partisan manner by lowering the husband's income and by paying the husband's fees, it's a no-brainer to join them to the action. And the current rule of court, they've been renumbered, is 5.24, and they said that the corporation was indispensable for the determination of an issue, the community property, and for enforcement, because it was clear that this corporation was not going to cooperate. They were going to continue to favor the husband. So I don't know to what extent people are actually joining third parties. And I'm not talking about pensions and the like, obviously. I'm talking about companies and entities. But I'll tell you, it's a very credible threat, because if you actually join somebody who's being obstreperous or being partisan, as the Schnabel court talked about, they're literally a party to the action for all purposes now, right, Chris?
Yeah, and that's where I think that modern practice is avoiding joinder because of that reason. We don't want. I mean, it's bad enough that the two parties have to go through a divorce. Now we've got a third party involved, and that raises a lot of problems. I mean, we all want to do it because now we've got a deep pocket that is going to be for attorney's fees purposes. Family Code 2030, I think G says that you can look to a joined third party's finances and making a fee award. So that's what everybody's like usually focused on, like why they want to join. But we got to think about the practical implications. This joined third party has a right to a jury trial on their joined claim.
Maybe.
I mean, typically, it depends what you're suing them for, but you gotta do a cause of action. You can't just join them. You have to join in a cause of action. And what's that for? And that may give them the right to a jury trial. And if they have a right to a jury trial, we don't, in a family court action, have that. So now you create some inconsistency there. And if they do have a right to a jury trial, basically you're not going to get a joinder. It's just going to destroy that possibility because we just can't accommodate a jury in a family court action. So we've looked at, well, what about coordination or consolidation of the actions? And I've seen courts that don't even want to get involved in that. They just say, hey, go have litigation against a third party in civil court and let me know how it turns out. Maybe they'll stay part of the family law action until that happens, but that's probably the best we can do. The other thing to think about is, so what if we do join them in, and what if we really like our judge? We've just added another party, which means they have a 170.6. And if they are aligned with the other side, that means the other side hates our judge, and they're going to use the 170 and ding our good judge. So, sometimes, you get what you ask for here. You have to be careful. What if we have a private judge, and we really like that private judge? We go and join somebody in. They don't have to use the private judge. So now they're going to object, and we're going to lose our private judge. So there's a lot of implications here, and I think that's why I don't see joinder being, I see it being threatened and applied for, but I don't see it being granted very often.
I'm not nearly as pessimistic as Chris is regarding the joinder as a remedy. I think there are workarounds regarding the right. First of all, I think a lot of the causes of action that you're going to plead in your joinder are equitable causes of action that may not even get you a right to a jury trial. Second of all, if you have a right to a jury trial, there's workarounds, whether we're borrowing, Department 4 or something with someplace else with a jury box downstairs, or whether we're splitting it up. There are ways to do it procedurally that work if you can convince your judge that it's appropriate. And I think that people may shy away from it because maybe for a variety of reasons that are not well taken. I think joinder should be pursued more aggressively when you have the right case. I'm not saying to do it superfluously, but you have parties that basically say, I'm not going to cooperate. I'm not going to cooperate in discovery. And from that, you can imply they're not going to cooperate in enforcing a judgment either. And I think that's exactly why we have the joinder statute.
So what are the causes of action that you would plead against a third party?
Well, sometimes, we have a partial list here, for accounting, constructive or resulting trust, debt relief, if there's a dispute, partition, conversion, claim and delivery, if they're holding assets that belong to the community. Marriage of Siller talks about it being, that's 187 Calap 3rd 36, being appropriate when you're dividing a business interest. Those are some. And a quick trip to the law library or UCLA, and you pull out Bender's pleading and practice, and they'll walk you through the proper way to draft a demur-proof complaint.
And that's where it's been hard, because I hadn't done civil in so long, and last time I tried to join somebody, we have our family law judicial counsel forms for joinder, which are basically cover sheets, but then we have to have the actual complaint, and so that's something we're not used to, drafting a complaint against somebody in civil court. And so I think, looking at those forms of pleading and practice, and like David said, if it's an equitable claim, then they don't have a right to jury trial. But then we have to look at, what does that mean, equitable claim? So, the constructive trust, that's probably one of the big ones, but it's very difficult, because now they're going to bring in another attorney, the third party, that's going to tangle with you and make all kinds of objections here that we didn't get our pleading right. There is a new rule of court from, I think it was maybe earlier this year, but that don't allow demurs in family court and don't allow motions for summary judgment in family court. So I'm assuming those would apply to the third party, so they can't really demur, but the court still, I think, would be interested to know, is there a legal claim being raised here in this proposed complaint against the third party? And if you haven't stated a legal claim, then you have no basis for joinder.
Interesting question about the demurs. I hadn't actually thought about that. I do know the new rule does not prohibit claims for summary adjudication. So those seem to be still alive when you're dealing with a premarital agreement or a transmutation or the kinds of things you would bring a summary adjudication motion for. But good question about the demur. I don't know.
One other statute that's worth taking a look at if it's a child support case is Civil Code 1714.4, and that's in the materials, but it's a relatively new statute, maybe a couple years old, but basically creates a penalty against a third party if they knowingly assist somebody in avoiding their child support. And so it says, any person or business that knowingly assists a child support obligor who has unpaid child support to escape or evade or avoid paying court-ordered or court-approved child support shall be liable for 3 times the value of that assistance provided, such as the market value of assets that were transferred or hidden, or the amount of wages or compensation that were paid but not reported. Now, there is the maximum limitation is the entire child support amount due, but that's a pretty good hammer. And so if you have a third party that, like an employer, that's paying somebody off the books because they don't want, their wages to be withheld for child support, this is somebody to be looking at now as a target here for this penalty. So I haven't seen it used. I don't know if there's any cases on it yet, but it's pretty powerful stuff. We have a question, or I'm sorry. Another thing is you can do a debtor exam of a third party. And again, in the materials, but CCP 708-120, if there's a judgment creditor, a judgment debtor, we can bring them into court and ask them a bunch of questions, sort of like a depo in the hallway. But that right also extends to third parties. So if there's a money judgment there against a party, third parties may be ordered to testify in court regarding the debt that's owed. Receivership is another thing that I think might be, more applicable in some of these business cases than a joinder. I mean, we don't necessarily have to. I mean, maybe taking that business, say if it's a husband or wife, operated and owned corporation, putting it into receivership so we can have somebody there that's protecting the records, making sure that changes aren't being made to the business. Now, that's a pretty extreme remedy, and I don't know if you've, been using it, but it's a tough one.
I have not.
Okay. And also, just restraining orders we have. I mean, the court has the ability to make restraining orders against third parties, and but now we deal with limitations of, do we have to put up a bond or an undertaking? I mean, what exactly are we restraining them from doing, and do we have to put up a bond in order to get that action? So that's going to be, a difficult one. A final point is on litigation privilege, and when we're dealing with third parties, we have to be very careful here, because normally anything that we say in a lawsuit is privileged, or that a party says about another party in a lawsuit is privileged, and they can't be sued for that. But there's an exception for family law cases, and Civil Code 47 says that in a family law action, statements about a third party are not privileged unless they're relevant to the action and contained in a declaration and not made maliciously. So if we just write a brief and saying, hey, judge, third party so-and-so is a crook, and they're a cheat, and they're a liar, and they're cheating on their taxes, and they're conspiring, and all these awful things that they're doing, that is not protected under litigation privilege because it's not signed under penalty of perjury. It's in your brief. So I think it's just for us to be aware that not to create any liability for ourselves or our clients. If we're going to say something bad, put it in a declaration.
And on that note, thank you all for your attention.
Our next panel, to my immediate left, is Brian Lepak. Brian's a certified specialist, and he's a partner. Oh, I'm sorry, one more. Please. All right. So for our panel, on my immediate left is Brian Lepak. Brian's a certified family law specialist. He's a partner at Trope & Trope. He's also a member of the executive committee of the family law section of the Beverly Hills Bar. On his left is Judge Thomas Trent Lewis. Judge Lewis is the Assistant Supervising Judge of Family Law for the Los Angeles Superior Court. He sits in Department 79. Judge Lewis, prior to taking the bench, was a family lawyer. He's been a certified specialist since 1985. He's a fellow of the AAML. He's been the president of the California chapter of AFCC, and we really appreciate him being here today. Left of Judge Lewis is Dr. Ian Russ. Dr. Ian Russ is a therapist, custody evaluator. He teaches co-parenting classes, and we really appreciate Dr. Russ being here as well.
Thank you, people, for coming. I want to point out that there is a handout in the materials that you've received, It has detailed information in a PowerPoint type of presentation. We are not going to be following that as an outline for this program. I encourage you to read it at a later time. Instead, what we're going to do is we're going to have a panel discussion with the three of us on 3 topics. The 3 topics are going to be, number 1, discussing social media with clients. Number 2 will be evidentiary issues regarding social media. And number 3 will be the impact of social media on child custody evaluations. So let's start the presentation by defining social media that we're going to be talking about today. Not saying I'm following the outline, but on page 2 of the outline is a definition of social media, and I'll just read it quickly to you. And that's from the Merriam-Webster Dictionary. It says, forms of electronic communication as websites for social networking and microblogging, through which users create online communities to share information, ideas, personal messages, and other content as videos. So that's social media, and we're going to be discussing that, but let's get some familiarity with the audience on their use of social media. So by a show of hands, who here has a Facebook account? Pretty much the majority of the people here. How many have a Twitter account? Less people. How many have an Instagram account? About the same as the Twitter, okay. How many have a LinkedIn account? Most everybody. How many people are willing to let anybody have open access to their internet accounts? Only 1 person. 2 people. Okay, so we are going to discuss social media, and you need to know about social media because as an attorney, you have an ethical duty to be familiar with new types of information that are relevant to your practice. And one of those is, of course, social media. And I think let's start out the discussion by talking about interacting with your client on the issue of social media. And I'll start by asking Judge Lewis a question, and that is, what are considerations that an attorney should have if a client tells the attorney that they're going to clean up their website?
Call your malpractice carrier. Also, secure all of your assets with some third person. Commit a complete defrauding on all of your potential creditors because the lawsuit is coming. Potentially, the state bar investigation is coming. There's a recent non-California case where a lawyer told someone to go clean up their Facebook account to take certain things off of it in a wrongful death case, and the lawyer was sanctioned many thousands of dollars. You may also be involved in spoliation of evidence. So I'll throw the question back to you. What's the standard of care today for family law lawyers in terms of what they advise their clients about social media and postings on the internet that they've made?
I think there's a number of topics you can talk about with your client, and I definitely think you cannot advise your client to clean up their website because that is a spoliation of evidence, and you are subject to hundreds of thousands of dollars of potential liability if the other side has to do some extensive work to uncover that information. But you can talk to them about restricting what they say in the future, such as not boasting on the website, being careful about who you're friending in the future because you might be friending people who are going to report things to your opposing party.
You mean people actually create other personalities, avatars, to gain access to information on someone's Facebook account, for instance?
Well, you have a duty to be competent, but you don't have a duty to be zealous. And I think that steps over the line by being deceitful and trying to get information. And then you run risks of ethical violations, and you run the risk of illegally obtaining evidence, perhaps. And you can have your evidence excluded, as we will talk about later today, if you are using illegal means to obtain that evidence. But definitely you do not want to befriend the opposing party using somebody else to try to gain that information, because that will be used against you, possibly even in a child custody evaluation, that you are being deceitful to try to get that information.
But there's another piece that I assume everybody knows already, and that is if you put it on the internet, it's likely that somebody can find it there forever, even if you think you erased it. And that's something important to remember.
I think that there's some cases that you will see in the handout talking about reasonable expectation of privacy. And what I would tell a client is there is no expectation of privacy. That's the point of an internet site, is you want to put stuff out there for others to see and others to interact. You don't want it to be private. Even if your settings are that you wanted to have it only for your friends and not for the whole public to see. I think the fact is, if you're showing it to some friends, you're not keeping it private. So I think that's going to come back against you. If it's on the internet, I would think of it as being out there in the public, and you're not going to be able to restrict access that much to it. Although there may be some limitation, I don't think you as an advocate for your client is going to get unlimited access to somebody's Facebook account, probably. You may have to tailor what you're asking for from that Facebook account.
But here's how it comes to me, okay? So you put it on there and you had a limited list of friends. Okay, one of those friends now is angry at you. They copy the Facebook, they give it to the other parent, okay? They print it out and they give it to the other parent, and then it's submitted to me in the process of the custody evaluation.
Let's just take a little survey on technology issues anyway, because some of us are saying, well, I don't do this stuff, so why is this important? So let's just take a survey. You don't actually have to raise your hand. Some of the questions are going to involve generations where perhaps raising the hand is painful. How many of us have practiced in the era of using carbon paper? Okay. And how many of us are still using carbon paper? None of us. And how many of us still have a pager? Okay. And how many of us still have or have used in their practice a mimeograph machine? Okay. How many of us in our practice have used the internet? Of course, now that's everybody. And so partly it's a generational thing. Most of us in this room are in a generation, and the younger you get, the less important it becomes, where privacy is at a premium. The idea that things are private, that they're confidential, is at a premium. Mostly that's pre-baby boomers and above. Whereas for Generation Xers and earlier, privacy is not viewed with the same high degree of concern. In fact, narcissism that leads to exploiting and leveraging off of our presence, if you will, is why Facebook has millions and millions and millions of users. I've talked with my son. He's exactly 30 years younger than I am, so he's 34. If you need to do the math, I can tell you what that means. And he points out to me that Facebook now pretty much is more dominated by baby boomer generation and less so by the 30-plus-year-old generation. They're using Instagram. It's no mistake that Facebook bought Instagram because of the use of it. Pictures posted all over the place of ourselves. And I think you were saying that there's another technology that's become popular.
My children use Vines, where you're making videos, short videos of each other, and then they look to see how many likes you get on your video.
So I'd like you to think about this as Cyberland, and to think about it in the way that immigration has happened over time to the United States. In any era where there was immigration from any particular culture, you have adults coming in who speak a native language, and you have children who grow up speaking English, and the children know the language better, they know the culture better, they know the community better, they know the ins and outs better, they know how to hide things, they know how to trick things. They're going to use all of their adolescent skills in something that their parents are far less adept in. Okay? And that's going to be the dynamic, and we're seeing it already in the next generation. So it's not just people over 60 who, have kids in their 30s, but it's now the 35-year-olds are now going to look at their kids because this immigration process is happening so quickly. And when I look at families, I kind of understand that kids have access to this information and an understanding that in most cases, unless their parents are working for a computer company, okay, the parents don't know what's going on. They don't understand it. I went out and I bought a parent education book for Facebook to kind of prepare for today. When I opened up my Facebook, if I had gone through that, it would have taken me 4 days just to open up the Facebook account with all of the different possible settings, the possible implications of it. My kids know that stuff like the back of their hand. Okay? So it's a very different world, different process, different language.
Getting back to things you would discuss with the client, I think another thing you'd want to talk about is possibly defriending some of the friends who you think might share information with your opposing party. I think that's okay to do. I think I'd also talk to the client about not acting in contempt of court, not blogging about what's happening in court and what happened that day in court, and bad-mouthing the judge, and bad-mouthing opposing party, and bad-mouthing a lot of other people. I mean, I think maybe it's a good thing to post nice things. I would talk to the client about posting nice things about the opposing party. How would that impact you in an evaluation if you started seeing suddenly somebody's posting nice things when they used to post bad things all the time?
Liar, liar, pants on fire.
Well, there are a couple of ways that I would create hypotheses, okay? I would create some hypotheses. One is, well, is this coming from the attorney who told them to do this? Are they actually learning something? Even if it came from the attorney, might they be setting up a better process of communication? One of the difficulties that I have is that you get tiered communications, so that I got families who communicate on our family wizard, okay, nice, decent, little jabs here, little jabs there, little nastiness, but kind of okay-ish. Okay, then one of them brings in the text messages where they're cussing at each other and yelling at each other, except it's in text messages. And I had one family who went, a family that was divorced, that went to a third step, and they were still doing sexy stuff on FaceTime.
So you mean when they text F you, it doesn't mean follow up?
Did not mean follow up. And then they were doing sexy teasing with each other on all the video opportunities that you have on the internet. And so there were 3 processes of communication that were available to them, kind of public, what they thought was going to be private, and what they thought was going to be very private, but they were continuing to communicate that way.
Speaking.
The evaluator, how would you look at a scenario like that if both the parents are participating in that kind of behavior and that 3 level of communication?
I described it.
Right.
Okay, so part of my issue is to describe what the levels of communication were, and then I described how the relationship worked and the complexity of the relationship, that they did have these 3 different ways of communicating with each other, and I wondered out loud whether or not there was some kind of profound sexual attraction that was still involved in the relationship.
Okay, so speaking of sexting, why don't we talk about that briefly? Judge Lewis, what considerations are there for an attorney if a client tells the attorney that the client has pictures of child pornography that they took off the opposing party's computer?
It's interesting, a year and a half ago, approximately, the New York Times had an article in their weekend magazine about the issue of sexting and how popular this is with kids. And of course, we can all remember back to the days of junior high when it was pretty well known about some girl who was willing to do various things. And everybody knew who that girl was, or that guy, for instance. Now, that's a whole different world. Now this information is being recorded, shared, used as a tool for bullying. And so the New York Times says, well, we should just relax about all of this stuff because this is what kids do and this is their new way of communicating that information. The only thing that's wrong with that view in the New York Times is it is not the law of the land. I know the New York Times thinks that they are the law of the land. Sometimes they're right, but they are not the law of the land. So I think it's important to differentiate between evidence that is illegally obtained and evidence that it is illegal to possess. And pictures of a 17-year-old girl or boy, or younger for that matter, that displays them nude, that's evidence that's illegal to possess. And so if the client is coming to us saying, I want you to take possession of this evidence that is illegal for you to possess, I want you to imagine that your client came to you and said, I got 50 pounds of cocaine in the trunk of my Mercedes, and I was wondering if I could drop it off with you. And the answer there, of course, would be an immediate, can I use it for shall I take possession of evidence that it's illegal for me to possess? And the answer should be no. Now, of course, the temptation, the little voice on the other side is, yeah, but this will really destroy the other side. That's not a good reason for you to take possession of evidence that it's illegal for you to possess. So if the client says, well, I have it here on a disk drive, or they mail it into you, now you're in possession of evidence that it's illegal for you to possess. The smart move for you is to talk to an attorney who practices criminal law, quite frankly, because lawyers who practice criminal law know better than most of us who practice family law what the issues are, because frequently, for instance, criminal law lawyers will become in possession of a weapon that was used in a crime. And there are ethical rules about what you're supposed to do when you become in possession of those kinds of things. And a good criminal law lawyer is going to tell you that it needs to be handed over to the police. In the case of child pornography, it needs to be handed over to the FBI. What you don't want is for you to be opening up attachments and then downloading them and saying that you're going to go ahead and become the repository of that information, because it will make all of your data subject to a search warrant, federally magistrate issued, to gain access to this kind of information. And as perhaps we could say, oh, well, the culture is there's so much of this, then therefore why be worried about it? To which I would say there is so much methamphetamine use, why worry about becoming in possession of methamphetamine? Would you actually make that argument to yourself? Now, maybe if you needed a quick dust up, you might say, yes, I will take possession of the methamphetamine, strictly for research purposes. But I think that the better view is that we should, as lawyers, become concerned about, and mental health professionals as well, whether or not we are becoming in possession of evidence that it's illegal to possess. And there are proper ways to make sure that you're no longer in possession of that. It's a serious enough issue that I can tell you that it has been addressed by court counsel in some counties where there's child pornography information that's been placed in the court file, and then the question becomes, is the court, meaning the bench officer or the staff, in possession of child pornography? And the answer, by the way, is no, because the judge is not in possession of the file. The file is a matter of public record. Now, what ends up happening and whether that gets sealed or sequestered or otherwise is on a case-by-case basis. But if you think it's not a serious issue, just avoid the temptation, I think, is the most important thing.
Okay, and then the last thing I would say that I definitely need to talk to the client about is passwords. And I think you have a duty as an attorney to tell your client to change their passwords, because their spouse probably has those passwords and could be accessing the material during the litigation process.
And we had this discussion as we were preparing for the class. You know, before separation, you're photo sharing, you've got photo stream, you've got document access, that everything is pushed to maybe a family Dropbox account, or accessible through photo stream or iCloud or whatever the other alternative is through the Android operating systems. And that was all opened during the marriage. And so then the question becomes, do you change those passwords? There's a whole other host of other fiduciary duty obligations, particularly if there's financial information there, that don't address issues that we're going to talk about today. But if your client isn't changing his or her passwords upon separation, that's, I think, a very serious consideration.
I think similarly, you have to tell your client not to be accessing the other party's data through their knowledge of the passwords of the opposing party, because that has some potential criminal implications as well. All right, so let's turn now to evidentiary issues with regard to social media, and that's really going to come in two phases. One is trying to obtain the social media, and the other is trying to introduce it into evidence. So let's first talk about obtaining social media. There are no set rules in California regarding electronic discovery, but there is in federal court. Rules 26 and 34 of the federal rules do discuss obtaining electronically stored information, ESI. And one of the what is being developed in federal courts, which will probably bleed down to our state courts, is the concept of not reasonably accessible. So you can ask for somebody's emails, that's accessible. You can ask for drives off of the computer, that's accessible. But how about data that can't be retrieved except for hiring some kind of computer expert? Probably that's not reasonably accessible. Something that's electronically stored on obsolete media, that's probably not reasonably accessible. So that's going to be a term, not reasonably accessible. That's probably going to come down into our state courts as well, as to whether you're going to be able to get some kind of electronically stored information from the opposing party. Another concept that you need to be familiar with, and it's again discussed in the handbook, is Stored Communications Act, SCA. That limits your ability to subpoena information from an entity such as Facebook. Even though you might be limited from subpoenaing the information from Facebook, you can get an order from the court to require the party to get the information from Facebook, because the party's not restrained from getting the information from Facebook. You, as the opposing party, may be restrained from subpoenaing the information from Facebook. So familiarize yourself with the Stored Communications Act, which again is cited in your materials. And I think we started to talk about expectation of privacy. Does anybody have any further comments on expectation of privacy?
I think we've touched on that sufficiently. Certainly, we'll talk about that when we get to evidence illegally obtained. I think that that's where the privacy issue probably has its biggest impact.
Then the one other thing I would talk about with obtaining social media is there's the concept of a hold letter, sending out a letter to people who may have information that you want to obtain. And there's some cases cited about whether third parties have a duty to preserve electronic information that you want to obtain, and generally the answer is no. But if you do send out a letter demanding the information and offer to pay to store that information or to make it sure it's not destroyed, then you may have an ability to require some third party to preserve that evidence. So you may want to consider sending out hold letters at the start of a case to make sure that the electronic information is not deleted, or send out subpoenas, business subpoenas, asking them to hold that information.
It may be wise, haven't really thought this all the way through, to actually file that as a notice in the notice pleading that's filed with the court, so that you've got the benefit of the presumptions that come from a properly executed proof of service, and it's in the court file. So it makes it much more difficult for someone to say, well, I didn't get that letter, or I didn't know, or you never emailed that letter to me, or you never faxed it to me. That's another machine that will probably be in the Smithsonian soon as a permanent record of sending things by facsimile. So I think that might be a way to rethink. This is, I think, a new area too, quite frankly, as it relates to electronically stored information.
So let's turn from obtaining the information to trying to get it into evidence. There's a phrase, but I don't know what.
Electronically stored information,
let's talk
computer
about-
generated information?
No, we'll get to that in a moment, but
Okay.
rash.
Rash,
What is
sure,
that? It's
sure.
not an idiom. What's the word?
Yeah, okay.
There's a phrase for when you have initials that mean something. I forget.
There are.
And
A
what's it
rash is not,
Yeah.
rash is not, well, rash is something that you may have acquired, and it'll go away, don't worry, and they have medicine for it. But that's not the rash that we're talking about here. So let me just make a quick offer to you. There are some slides that are not in the materials that are derived from a program that Justice Mark Simons and I do on evidence. And if you want, I'll be happy to email you some screenshots in PDF. And the email address to write me at is judgettlewis@gmail. judgettlewis@gmail. No dots till you get to the com. Okay, judgettlewis@gmail. And I'll send you some of the things that I'm going to talk about now. They are tools that you can use to make sure that you have planned out the admissibility of every piece of evidence. And electronic evidence is sometimes confused when it comes to the idea of electronic discovery versus the admissibility of evidence that is stored electronically. The difference between electronic discovery of electronically stored information versus the admissibility of evidence that is stored electronically. So I want you to write down 2 evidence code sections, which you may or may not be aware of. The first is evidence code section 1552, and the second is evidence code section 1553. So let me answer the question, what is RASH? RASH stands for the following. R is for relevant, A is for authentication, S is for secondary evidence, H is for hearsay. R is for relevant, A is for authentication, S is for secondary evidence, H is for hearsay.
By the way, this is all in your materials as well. In the
So, you have to go over every hurdle to get evidence to be admissible that's electronically stored. Fortunately, 1552 and 1553 assist you with respect to the authentication-related issues. Each time you're trying to admit a piece of evidence, of course it has to be relevant. We're not going to even spend time talking about that. Writings are generally authenticated by showing that they were actually made by or signed by the purported maker. So that's not that hard to do, and here's a quick example. Mr. Lepak, is your email address brian@yahoo.com?
Yes,
And did you access your computer to retrieve emails between yourself and your ex-wife?
I did.
And did you print the emails?
I did.
And did you modify them in any way?
I did not.
And is your computer operating system properly operating to your knowledge?
It is.
And I show you a document that's been marked as Exhibit P1. Do you recognize this document?
I do.
Sir, do you recognize this to be a true and correct printout of the email strings between yourself and your former spouse?
It is.
And is her email address lisa@yahoo.com?
Yes.
And are these true and correct emails between you and Lisa?
Yes.
You have now properly authenticated under 1552 the email string. Now, one common argument is made that her emails are, of course, what? They're admissible hearsay admissible hearsay because they are the statement of a party. They don't have to be, even though the evidence code calls it a party admission, it doesn't have to admit something. It doesn't have to be a declaration against interest. That's a different hearsay exception. Now, how do we get Brian's emails in? Those are hearsay. And by the way, I'm offering them. So they're technically not a party admission, but they do help to explain. And an evidence code that is frequently underutilized in family law is Evidence Code Section 385. Excuse me, 356. 356 of the Evidence Code is the doctrine of completeness. If the only way that I can understand, the second email in an email string or the fourth Instagram in an Instagram string or the ninth text in a text string is to have the other emails or texts or Instagrams come into evidence. Evidence Code Section 356 makes that which is otherwise probably hearsay and not admissible now admissible because it connects the chain of connectivity of the thought. So this connectivity paradigm is frequently misunderstood in evidence code proceedings where we're arguing that the statements made by Brian, offered by his attorney, are hearsay. The answer is they are hearsay. But the problem for the person objecting is that under 356 of the Evidence Code, this now becomes admissible. And the string I just used of questions with Brian would make Petitioner's Exhibit 1 admissible, assuming that it was relevant. Now, as to the third element of the rash, because it's got to be relevant, we've authenticated it, is the question of secondary evidence. Now, for those of us who are a little older and perhaps have forgotten, we used sometimes call this the best evidence rule. The problem with that is that we haven't called it the best evidence rule since the 90s. So welcome to the 21st century. This is where copies of documents, properly authenticated, otherwise admissible, can be received unless there's a genuine dispute about whether or not it's a correct copy. Here's the real question that we now face in the 21st century. What are original documents, and are there any? For instance, is it the first iteration of the PDF that was saved and scanned? Is it the second generation? Are there original documents? Now, because we still live in the world that we live in, there are some documents that actually have wet ink that was applied to them that are filed in court proceedings. Deeds, for instance, are a good example of original documents. So the secondary evidence principles are not that hard to overcome. So relevancy, we're going to assume that you've got something relevant. We've now talked about authentication. We've talked about secondary evidence. Now then, of course, the hearsay, and we've touched that as it relates to most of the electronically stored information that we see. Because it's either going to be a party admission or it's going to come into evidence under 356 in terms of connectivity. So that's probably more than you wanted me to answer, but there's your answer.
Well, I'll go back a little bit on authenticity. Isn't websites such as the government website self-authenticating?
Well, it's not necessarily self-authenticating. You would still have to meet 1552. It may be admissible hearsay because it's an official record. That's the way to do the analysis isn't, was it authenticated because it's on the government website, assuming the government website actually works, but that's another story. Just because the way you prove the authentication of it is different than the issue of whether or not it's official information that could otherwise be admitted into evidence as a hearsay exception.
Okay, then let's focus a little bit on hearsay. I think there's two terms that everybody here needs to know about, and that's electronically stored information, ESI, and computer-generated information. Two different concepts that I know Judge Lewis knows very well, and I'll let him explain the difference between the two, because you need to know the difference.
Okay, so, Mr. Lepak, did you turn on your computer?
Yes,
And did you look at the clock on your computer?
I did.
Objection, hearsay. Is that hearsay? What the clock on the computer says? And the answer is, it is not hearsay. Because what? The computer is not a speaker. It is not a speaker. And what did the computer clock say? Now, of course, computer clocks don't say anything, right? We read them. We say the clock on the wall says 1 o'clock, but the clock isn't saying anything. The clock is just there, showing what the time is. So this is computer-generated information. Mr. Lepak, did you access your computer?
I did.
And to your knowledge, is the operating system of your computer properly operating?
It is.
And did you go to the directory of your computer?
I did.
And when you went to the directory of your computer, did you look at the Finder log in terms of accessing of documents?
I did.
And were you able to determine whether or not the nasty letter that was written on the computer, which has already been received into evidence, was written by your wife?
I was.
And how were you able to determine that?
Based on the,
Is it because the Finder log showed that she had created a document on March the 1st of 2012?
Yes,
And is this a true and correct printout of the Finder log of your computer?
it is.
That's all computer-generated information, not hearsay. All of it is computer-generated information, not hearsay. So, properly operating computer, evidence that it's properly operating. Now, qualified to say that it's properly operating, probably not going to get too far with that one. Did you turn it on? Yes. Could you access the information? Yes. Had it been, modified in any way? Did you modify this in any way? Answer, no. Now, here's one little tip, however, that you at least want to be aware of, and that is you can take an email string. For those of us that are, I won't say that, to be a lawyer or a judge, you have to have a little larceny in your heart, because that would be an unfair statement. But here's factually what can happen. You go to the email string, you block copy it to Word, you save it as a document, you go into the document and modify it. You save it, you print it, and someone testifies that it's a true and correct printout. There are risks with respect to this. 1552 and 1553 only create a rebuttable presumption that it's authentic, shifting the burden to you to show that something nefarious has been done. Electronically stored information, the best case law tells us that ESI, electronically stored information, again, differentiating between evidence that's electronically saved versus electronic discovery. They're very different things. All of the cases talk about documents using analogies that are well known to all of us, using the file drawer analogy, using the bulletin board analogy, using the list of letters. So the same way that we think of that, now all of that's hearsay. All of those documents are going to be hearsay documents. You're going to have an exception to get that information into evidence, including, for instance, a party's Facebook page, a printout of a party's Facebook page. Is that hearsay? And the answer is yes. Can it be admitted into evidence? And the answer is yes, as long as it's relevant, you've authenticated it, you overcome secondary evidence because there is no primary evidence, it's all electronic. And of course, if it's the other party's Facebook page, it's probably going to constitute an admission and admissibility as that admission.
So there are some cases in your materials that will help you to understand the difference between ESI and computer-generated information. For instance, there's a case in which there was a header on some photographs in a criminal case. The header had the name of the sender, the date it was sent, the internet provider address. That header was generated by the computer, not by the human input. That's computer-generated information. That's not hearsay. That is admissible. Photographs taken of you running a red light, that's generated by the computer. That is not hearsay.
Well, that question actually hasn't been answered yet by the California Supreme Court. It will be answered, and I think it will find out that it's not hearsay. When the dog sniffing, Mr. Lepak, do you work for the DEA?
I do.
And did you take Ralph the Wonder Dog to search the house of Barry the drug dealer?
I did.
And did the Wonder Dog bark and point?
He did.
He did. And when you looked in the place where Wonder Dog barked and pointed, did you find 50 pounds of methamphetamine?
I did.
Is the fact that the Wonder Dog barked and pointed hearsay? And the answer is no, because the dog isn't speaking. Now, perhaps on certain cartoon shows or late at night, back in the 60s, you knew some talking dogs, but dogs don't talk. And so this is not an out-of-court statement by a what? Speaker, just like the computer, probably like the red light camera as well.
Okay. Even though we've talked about rash, that doesn't complete your analysis with regard to whether something is admissible, because there are other ways of potentially keeping out that which would have passed rash, such as something being prejudicial.
Right, that's a 352 issue. More, the probative value versus the prejudicial effect. These issues, largely, well, Your Honor, we'd like to admit this picture of Mrs. Jones flying naked in a trapeze in front of the children at the third grade school. Now, in a jury trial, of course, there would be a separate hearing about whether or not that evidence would come in. Now, do you think the judge isn't thinking about Mrs. Jones flying in a trapeze with no clothes on at the third grade class? So the prejudicial effect issue is pretty remote in terms of whether or not that's the most important objection that you could make. There might be the time when it is appropriate to do it, but remember, you have rung the bell if you're making that objection. Maybe you should just be hoping that the judge is drooling his or her, carefully paying attention to the evidence that's being presented and just move on. The amount of time that it takes to put the evidence on. Your Honor, we would like to have you read 40,000 pages of texts between the parties, which we have stipulated come into evidence.
I thought only evaluators had it.
Yeah.
We'll get to that momentarily.
Yeah, so that might be 352, the undue consumption of time. So that may very well be a way to keep that evidence out, unless you had something else you had in mind.
I did.
I'm
That
sorry
would
I
be
missed it.
illegally obtained evidence.
Illegally obtained evidence. Okay, so here's a couple of code sections you want to write down. They're in the materials that I offered to send to you, along with a couple of the exceptions. So the first is our specific family law code section, and that is Family Code Section 2022, illegally obtained recordings. Now, the use of the word recording, of course, shows how old we are, because most of us are thinking of something that sounds like a cassette tape or eavesdropping on the phone line. Certainly those all qualify as recordings, but it's much broader than that. It can include, for instance, using the record memo function on your Galaxy or on your iPhone. It can include key logger devices, which are sometimes used where you can actually record every single keystroke on a computer. Whether or not you installed that on a community property computer before you moved out of the house, and whether or not that is now illegally obtained evidence is a question that we don't have to answer today. Now, there is one clear exception with respect to eavesdropping recordings, and it is the common exception. And this is another code section that you're going to want to write down, is 630 generally talks about exclusion of various kinds of illegally obtained evidence, and 633.6 is the specific exclusion for what? DVPA orders that provide that a party can record communications. That's a statutorily created exception. So otherwise, generally speaking,
Is that with all DVPA
if there's
order?
a DVPA order and the court has checked the box that says that you may record communications from the other party, then it falls within the exception under Penal Code Section 633.6 for admissibility and use, which would still require, of course, that you show a rash. So let's do one more example about evidence that was illegally obtained. Mr. Lepak, did you record all of the phone conversations between yourself and your ex-wife?
Is my attorney going to object on?
No, I'm actually asking you this question.
Yeah, I did.
I'm your lawyer. I'm dumb enough to ask this question. Did you do that?
I did,
And did you keep those recordings?
of course.
And do you have a specific, the answer is no, by the way, to this question, a specific recollection of the conversation that you had with your wife on March the 1st of 2013?
I had so many, I can't remember that.
If I showed you a copy of the transcript, and this is a copy of the transcript of the conversations, would that have the possibility of refreshing your recollection?
Oh, yeah, sure.
Oh, yes. Well, I would ask you, would you please go ahead and review that transcript? Objection! Illegally obtained evidence. What's the ruling of the court? Overruled. Believe it or not, and it's in the materials I'll send you if you want it, is a case called Frio versus Superior Court. Now, in Frio, what I just did in our little family law session was done in a case involving an action by a party against the studio. Someone believed, I don't know, I've only heard about these kinds of lawsuits, that someone believed that the accounting department of the studio wasn't properly paying out a share of profits. I heard these cases come up once in a while. They mostly occupy the 7th floor of the building and downtown. But these things happen. And in Frio, that evidence, which was illegally obtained, was admissible and permissible to refresh the recollection of a party. I don't write these, I just report them. Okay, so the 2nd District Court said that that's okay to do. Now, let's go fast forward to another example. Mr. Lepak, did you hire Murray the Gonoff Investigation Services?
I did.
And did Murray's firm break into the Disney studios?
He worked very hard and got me the information I needed. Yes, he
And
did.
did the information show that the studio had not been paying your estate the share of the Winnie the Pooh profits?
Absolutely correct.
Yeah, they did. Now, you're asked to rule on the motion to dismiss the lawsuit of Schlesinger versus Disney. And what's Disney's defense? Yeah, we lied, but they broke into the studio. They didn't pay attention to the guy with the hat. They surreptitiously came onto the studio. They obtained this information illegally by committing a trespass. So we want you to dismiss the lawsuit, Schlesinger versus Disney. And what's the result? The trial court says, you were a bad, bad boy, Mr. Lepak, by having Murray the Gonoff steal that information, even though Disney has been depriving you, which we have to take to be true, although not necessarily true, of course, depriving you of your share of the profits from Winnie the Pooh. Your case is dismissed, affirmed on appeal by the Second District Court. So the boundaries of illegally obtained evidence are as we've described. Of course, this says nothing about the fact that when the client comes to you and says, oh, I have this illegally obtained evidence, shall we use it to refresh my recollection? You might want to go, hello, I don't think so. I don't think we're going to have you admit that you participated in this fraud. And I'm certainly not going to admit that I knew anything about it, and we're not going to put that evidence on. With the other extreme being, of course, that if you end up with your case so tainted by evidence that was illegally obtained, whether or not that results in striking out, for instance, the evaluation report, where surreptitiously provided tape recordings are presented to the evaluator, who then writes his or her evaluation report. Or
But even if I get that and I don't open it and I wait until, and I say to the other side, do you have any objections to this? And I don't hear anything?
and then you open it.
Right.
And then I find out, well, Mrs. Lepak or Mrs. Lewis finds out afterwards that it was illegally obtained evidence. Then the question becomes, should your report be stricken?
Can we talk really quickly before we move on to the next topic about videos and how to get those into evidence and special considerations in that regard?
Sure. Videos are just another form of document. So the paradigm is really the same to get a video in to evidence. We have to authenticate it. And for each kind of document, there's a different set of rules. So, Mr. Lepak, do you have an iPhone?
I do.
And did you take some pictures with your iPhone?
I did.
And did you take some videos with your iPhone?
I did.
And is the operating system on your iPhone properly operating to your knowledge?
It is.
And did you download the pictures?
I did.
And I show you what has been marked as Exhibit P3 and ask you whether or not that picture of your wife flying naked on a trapeze in the third grade class is a true and correct copy of what you found, what picture you took with your iPhone.
It is.
And does it accurately depict the events that took place at the time when your ex-wife was flying naked on the trapeze in front of the third grade class?
Yes.
Have you altered it in any way?
No.
Have you photoshopped it in any way?
No.
Move to admit, Your Honor. What's the ruling? Admissible, at least as to authentication. Because it has to reasonably depict. Now, did you record your ex-wife at the third grade class talking about how much fun she had?
I did.
And did you download that to a memory disk, which we can play here today?
Yes.
And, Your Honor, I'd ask for permission to play the video. Objection, no transcript. Sustained. If you're going to play a a tape recording, and therefore I think by extension a video recording, and there are voices on it, you have to have a transcript of what was said. And there are special rules about portions being unintelligible and whether or not you can knock them out. And keep that information out of evidence. So the takeaway with respect to all of these things is, oh, and by the way, Your Honor, we'd like you to just go ahead and look at the phone. No problem, counsel. Is the phone being offered into evidence? Oh, no, Your Honor, we can't do that. That's my client's iPhone. We just want you to read the things that are on it or listen to them or watch the video. I don't think so, counsel. not properly authenticated, number one. Number two, no way for me to keep it in the evidence file without it being received into evidence. And oh, by the way, no transcripts. The transcript piece is the piece that's most frequently overlooked by lawyers. So whenever it comes to these kinds of data, you should have a plan for admitting this evidence that meets each one of the RASH requirements: relevancy, authentication, secondary evidence, and hearsay. Every single one of them, and the specific rules for videos and the specific rule for tape recordings. The video requirement, the picture requirement, and the writing requirement, the only main difference between those is the requirement of a transcript if you're going to use a recording of voices.
So as an evaluator, I don't have any ability to authenticate anything. I have it in my contract that I'm not responsible for authenticating anything. If I get an email stream, not our family wizard, but independent, and nobody's objected to it, I'll put a note on, by the way, I can't authenticate this, but I'm kind of accepting it.
And it's juicy enough that I should consider it anyway.
Right, but what happens, I'm in the last session, okay, my last interview, and the parent takes out a phone and says, oh yeah, and I just got this message yesterday.
It probably sounds like information that hasn't been provided to the other side. You know, I do know, and we talked about this in preparation for this, you know, there are programs out there like Dropbox, and there's another one that I've been told about called Basecamp, where the parties upload all the information that they're going to give to the custody evaluator, so it's easy to track what's been given to the evaluator, and whether or not you want to ask for that kind of technology to be used in your case, you know, is an important consideration. It's a very easy way to, we're going to take questions at the end. It's a very easy way to cause problems for the court that are insoluble. I know this only happens in some cases, never in any of yours. They didn't give me the documents. Yes, we gave you the documents. They didn't give me the documents. Yes, we gave them the documents. They didn't give me the documents. Yes, we gave you the documents. If there's a Dropbox account or use of some other technology where it's been posted, then it's very easy through computer-generated information to demonstrate that in fact they did or did not get the relevant information.
Let's turn to the impact of social media on child custody evaluations. So Dr. Ross, do evaluators have social media guidelines?
None. AFCC has none. American Psychological Association, as far as I can find out, have none. The American Association of Marriage Family Therapists doesn't address custody evaluations, neither does the California Association of Marriage Family Therapists. National Association of Social Workers has guidelines for custody evaluations, but I can't find anything having to do with social media, and I can't find any state laws about it, so none.
Do you have any comment about evaluators searching Google themselves to do evidence, to find out more about the parties they're working with?
I would have enormous concern about an evaluator going out on his or her own to investigate anything. That it's my understanding, I receive materials that are presented to both sides, and that's the set of materials that I have to review. And my understanding is that's it. If I were to know more about an individual, I would say in my report, you know, I want the court to know that I'm aware of these issues as well because I read it in a newspaper or something, but that my understanding is this is only about information that's officially supplied to me or in my interviews.
Okay, let's talk about how information gets to you. I know Judge Lewis has talked about maybe parties should get together or counsels should get together and talk about using a joint site to present evidence, but let's say we're old-fashioned and we're just going to give you hard copies of papers. Let's talk about any suggestions on how you're getting that information.
Yeah, it's best for me if it's actually organized, and there's a list of the documents that I'm receiving. And not only does it make it easier for me to kind of go through it and understand what I'm getting, there's a very practical thing. In the end, it makes it easier for me in my report to record all the documents that I receive so that everybody knows what it is. Otherwise, it takes a lot more time, and that increases charges for everybody that don't need to happen. But that, yeah, notebooks are very good ways to do it.
How about the 50 zillion emails that I need to give you about the exchange that our parties have been having with one another?
What I usually do is I request that each side can give me 3 months of continuous emails, okay? I tell them that for me to get 1 or even 2 emails out of context that I actually don't understand what it is or what the power of it is it just somebody got exasperated at the end of a day and they said something stupid? But so I want 3 months, and the best way that I can authenticate it is that to ask each side to submit the 3 months of email so that I can see if anything's missing, okay? But that's still very time consuming, but certainly better than having to sort through a year's worth of email.
But if you don't look at all 3 years, how can you really know the true picture of what's going on here, Dr. Russ?
There are times where on our Family Wizard where I might have access to 3 years. I might send a note to the attorneys that say, do you actually want me to spend the time to review all 3 years of email? Otherwise, I will develop a plan from doing research of saying I'll choose a month, I'll choose a month and then 3 months later and then 4 months later and whatever, so that I can get a sense of it over time. Is it possible that I'll miss something significant in that? Yes, but otherwise, it's a matter of creating a bill that I don't think has to be created.
Is there any type of social media that you think is relevant to help you in your analysis?
I think that for me, what social media largely is a couple of things. Number one, it gives me information about communication in the family. How are people communicating? Are they communicating? Is there information being shared? Is it not? What's the role of the children in that communication? Do children have access to it? So if it's going out on Facebook, okay, and the kid is a friend on the Facebook, then the kid has access to it. But even if the kid isn't a friend, but they know mom's or dad's passwords to the Facebook, okay, then they have access to all of this communication. It's not being done privately. So I'm looking at the family dynamics, and this simply gives me another piece of information about that family dynamic and communication. Now, what I do is I will take that, and then I'll develop questions for my final interview. And I'll ask the parents, I read this in your email. How do you think that was useful? So how is it helpful to call the other person, a son of a bitch? How does that, was that a useful communication? Where did it come from? And so on. Where were the children when this happens? Do the children have access to the computer and so on? So it gives me that. It also lets me know in terms of children's communication, it lets me know, are these parents attuned at 2 levels to the child? These are general questions that every evaluator would ask anyhow. One is, if you have a 12-year-old, is the parent generally attuned to the issues of 12-year-olds? In a general sense, and the second is the parent attuned to the issues of this particular 12-year-old? And both of those things are important, and so the media gives me information about that.
Well, speaking of age of children, is there any consideration that we should give to the age of children and their use of social media that you can comment on?
Sure. Facebook, okay? So Facebook lowered their age. It used to be that you had to be 14. Now you can be 13 and you can get a Facebook account. So what parents would do is that one parent would sign the kid up or give them access to a Facebook account below the age of 14 or now below the age of 13. Is that malfeasance of parenting? Is that abusive? Is that neglect? And so on? it has to be in the context, okay, of what's going on. Some parents do let their kids do things before age, because that's what all the other kids are doing. And there has to be some way of looking at that and balancing those issues. So yeah, if all the 12-year-olds in the kid's class is on Facebook and this kid isn't, what's the implication of that? How big a deal is it? How are the parents supervising? Are they giving access to both parents? I've had cases where one parent would not allow the other parent to be friended on the Facebook so that they didn't have any access to it. And that would be, so I'm looking again at how is this an expression of the family dynamics?
How about use of programs such as Grand Theft Auto and World of Warcraft? I have a boy who is using that at a younger age, and maybe that becomes concern for the other parent. How can we address that?
Those are value issues of when is a child ready for that. I can explicate the difference in the values, okay? But these are issues that parents always have that are differences of values. I remember many, many years ago, this isn't a computer example per se, I was on a panel with some Quakers, and they were talking about that they never gave the child access to guns or violence or anything else. And they were sitting at the breakfast table one morning, and the 8-year-old got angry at the 6-year-old, and he took his French toast, ripped it into the shape of a gun, and shot his brother. And that because it was there, it was available, they saw it, they know it, they're boys, that's what little boys do. So where kids get some of this is hard to know. They are going to go to their friend's house and play Grand Theft Auto. You have to know that. If you say, no, I'm not going to allow my 12-year-old to play Grand Theft Auto, and they got friends in the neighborhood who have Grand Theft Auto, they're going to be playing Grand Theft Auto. The same way that if a parent says, no, you're not going to look at this level of magazine, you're not going to look at Playboy or whatever, and they go to their friend's house and he's got a stash of Playboys, they're going to look at it. That's what's going to happen. So you have to balance those issues of, is the parent a helicopter parent? Or are they just kind of watching? Do they letting their kid fall down? I mean, but this is the balance of looking at parenting, and this is just another form of doing that.
Does that same concept apply to whether you should allow your child to have a computer in their bedroom as opposed to in the den?
What I would be looking at is, I think at very young ages, it's better to have a computer in a central room so the parents can easily monitor it. I think as you get to be a teenager, teenagers have a greater sense of privacy. The issue is are they abusing that privacy? This is a part of a child growing up and a parent entrusting them to handle things in a responsible way. Does the parent have some, is it an issue at all? Do they check where the child is going on the internet from time to time? Do they have any safety tools on the internet? How do they check that? Has it ever been brought up as an issue? It might never have been brought up as an issue, and the kid is a responsible kid and it's not an issue. That's part of the problem. One of the problems in an angry divorce is that if one parent sees that the kid is going to places they shouldn't be going to on the internet, they may be reluctant to ask the other parent, are you seeing the same thing and what do you want to do about it, for fear it's going to show up in court? You say, well, it happens over at Dad's house. He already admitted it. Want to see the email? And that reduces the sense of them to be able to communicate about it.
Any comments you can give us on parental consideration on how to limit a child's use of, say, a Facebook account?
Sure. You watch. You go into it. That you're going to be a friend on the account and you're going to watch it. This is something you're going to enter into and watch. Might you do, when the kid's 17 years old, might you have a different level of watching? Sure. But this isn't any different than how much do you watch your kid and how much do you give them freedom?
I think a parent probably has a responsibility to talk to their child about bullying other kids through the internet.
I think it's very important to talk about the issues of bullying. I think schools are doing it. I think that public schools, private schools certainly are doing this a lot in terms of education. What is bullying? The power of it. That, on the other hand, if the parent is made aware of it and they don't do anything, that's one thing. If they're really not aware of it, okay, then that's another issue.
Yeah. I mean, other things that I think it would be important to talk to your child about in the use of internet accounts are such as denigrating other people. There's likes or unlikes on Facebook, posting pictures of people that you took without the other kid's consent, and their kids are posting
And it
pictures to
means-
get others in trouble.
It means some level of watching, and some of it you're going to hear, and some of it you're not going to hear. The same way that if you heard your child say something not nice, you would stop them, hopefully, and say, come on, you can't talk that way. And so it does require a level of observation from the parents. Like, can children still say nasty things on the playground? Can they, say it while they're waiting for the school bus? They can do that. The question is the parent watching it enough? Is it good enough? When they hear something that's off, do they investigate it or do they let it go? That's the issue of parenting.
The problem isn't necessarily one parent not doing the good job. The problem is when you have another parent who won't do that supervising, and the child's with that other parent, half the time possibly, with the parent who's not supervising. How do we handle that situation?
Well, I think, again, if the kid is basically a good kid and that there's less supervision in one house than in the other, then he may not need all the rest of that supervision. Or it may be that he's a good kid because he's getting the supervision in one place and it carries over. If the child is having trouble, right, that is already identified, and then one parent isn't responding to that, it's not different on the internet than it is in any other areas. If the kid is bullying at school or if the kid's not doing their homework, it's the same issue. You need to be available to that child to intervene.
Quick comment here, and that is the issue. These are all important parenting issues in terms of making decision about which parent should perhaps have primary custody, or what the appropriate timeshare is between the parents, or decision making. It becomes more problematic when you come into the courthouse and you say, now I want you to make orders, Judge, that say that Johnny cannot go to R-rated movies. Let's use R-rated movies, for example. Now, last I knew, R-rated movies required that no one under 17 without, what is it? A parent or guardian present? Right. So if you might think, in terms of your own biases, it's okay for the kid to go and see a violent war movie. And I might not think that's okay, or I might think it's perfectly fine. So now the question is, how much is the court going to insinuate itself into making orders about things that are discretionary for parents to do? I might think it's not okay for a kid who's a teenager to have the computer in their own room. The question now is going to become, does that mean that I'm going to insinuate and make orders about whether or not the kid can have a computer in their room? Unless there's some key behavior where the kid has acted out in an inappropriate way, I think it's difficult for bench officers to be asked, don't let Johnny go to R-rated movies. Because why? Because you don't take him to R-rated movies, or I might not take him to R-rated movies. So there's lots of bias issues here. There's lots of parental autonomy issues here. When the interface comes back, circles back around from the evaluation into the court and orders that we're asked to make.
Well, as long as you're talking about court orders, why don't we give a little added bonus here and discuss maybe prior restraint, which comes up a lot. I don't want my spouse to say negative things about me on the internet. Can you, Your Honor, stop them from doing that, please?
Sure. So now we've got this issue. Let's just imagine that you wanted to take out a bulletin board. You're a little unhappy, and the bulletin board says, Bill is a bastard. Okay? So let's just assume that, the companies that do all of the bulletin boards, they'll let you, of course, put Bill as a bastard up on a sign. As long as you pay the monthly fee, they're happy to have you do it. So now the question is, where shall we place the bulletin board? Shall we place the bulletin board in front of Johnny's school? Shall we place the bulletin board 100 miles away from any place Johnny might ever go? Shall we place the bulletin board on the street that Dad has to drive by with Johnny every day to go to school? Now, again, I said most of the case law uses examples that come from current technology. Now, let's assume that we're posting that on the internet, that we have established a web page, the billisabastard.com webpage, where we are trash talking Bill all day long about what a bad guy he is. Under a recent case, Evans v. Evans, which was sort of a family law case, the issue of prior restraint and whether or not Mom and her mom, who were only trying to help the public understand about Dad, had opened up a web page that was the equivalent of billisabastard.com, trash talking Dad. Dad went to court, got a preliminary injunction requiring Mom to tear down and Grandma to tear down the web page. Reversed on appeal. It's a prior restraint under the First Amendment. So asking the court to make orders that a parent can't say that Bill is a bastard. Now maybe I can make an order that says can't say Bill is a bastard in front of Johnny, but that's different than saying you can't say Bill is a bastard. And we have a case that came out yesterday that involved a lawyer bragging about how he had sued Ford Motor Company and Volkswagen by revealing that there was asbestos in their cars. And he bragged about it on the internet. Ford and Volkswagen went to the Superior Court in Santa Barbara County and got a restraining order saying that this lawyer had to tear this stuff down off of the internet. Reversed on appeal, prior restraint. So we have that pesky little First Amendment that gets in the way of making orders about parents saying, posting, or sharing information. The issue is access by the kid, I think, if we're going to put any kind of prior restraint.
And I learned that initially when I got a complaint that mother had said nasty things about the father on her Facebook to her friends, and she had, I don't know, 45 friends listed or something like that. And my initial piece was, is this really any different than Mom being in a bar with her girlfriends or Dad being in a bar with his guy friends and, saying terrible things about the other parent, and is it really different? And when I brought it as a hypothetical to my kids, they said, well, yeah, it's different because the whole world ultimately has access to the Facebook because somebody shares it and here's how it works, okay? We just got 35 friends, okay? But the kid's friend's mom is one of those friends. And that mom shows it to the kid who says, do you know what your mom or what your dad is really saying on the Facebook and so on? That it has an availability that's very different, even if everybody thinks that it's just a limited group of people.
So why don't we talk about maybe appropriate restrictions on a child who's maybe not using social media appropriately? Any comment in that regard?
Absolutely. But it's going to take energy. It might mean having the computer in the living room. It's going to mean checking up. It's going to mean learning how to know where the kid is going on the internet. Looking at cookies and seeing, I wonder where these cookies came from, okay? That
As long as a kid doesn't look to see where you've been, it's fine, right?
That's right. And just in case, if you want to know now where those ads on Facebook on the right column come up, okay? Because when you go and you're going on the internet to check all kinds of stuff, Facebook knows exactly where you've been, and they gear the ads to it right away. Okay? That you need to know that. So they're checking that all the time. But in terms of kids, absolutely, it's not different than any other behavior, except that the parent might actually not know how to do it, and then they're going to have to consult with somebody.
They can ask the kid.
Yeah, that's right.
Well, what if I open up a website for my child and it requires a password? I know it. Do I have to share that with my spouse?
I think that it's better parenting.
I would agree. I think that's it for